Hi, this is Blair Pleasant. I'm here with my BCStrategies colleagues to discuss legal considerations when it comes to AI. And AI litigation is just beginning. We've seen a couple lawsuits already against some CCaaS providers around collecting and using customer information without notifying the customers that their interactions are being recorded and used without explicit consent. And we're going to be talking about that term consent a bit. There's a pending lawsuit against Google saying that Google AI eavesdropped on customer service calls and that Google's AI allegedly listens to and learns from customers' calls. But Google didn't obtain the customer consent for that and didn't alert callers that it's listening. And that infringes on consumer privacy rights, and it also violates California state privacy law. And I guess that's where the lawsuit was happening. And the lawsuit also argued that these practices violate prohibitions against wiretapping and unauthorized recording of communications. And then there's also the issue of using recorded conversations to train and refine Google's AI models. And, we hear all the vendors talking about, or not all, but a lot of the vendors talk about how, we've got such good models because they've been trained on all these customer conversations. Well, did the customers know about this and did they give consent to that? So that's something we need to talk about. TalkDesk has also been in the news when it comes to some of these issues. And recently, its customer Legal Shield accused TalkDesk, or a customer of Legal Shield accused TalkDesk and Legal Shield of secretly listening to, recording, and analyzing customer communications, again, without consent, and that it wasn't disclosed to consumers that their conversations with Legal Shield were being intercepted and analyzed by TalkDesk. There's also another lawsuit by Patagonia, or a Patagonia customer against Patagonia, that was dismissed. So there's a lot of this stuff going on. We're at the very beginning of it. So when it comes to AI and data privacy, especially related to the contact center and customer service, there are lots of issues we need to be thinking about. Prohibitions against wiretapping and unauthorized recording of communications, how the communication information and data is being used. Is it being used to train vendors' AI models? So again, the big issue is customer consent, company transparency, and disclosure of information. So there's a ton of stuff going on. And I'm not a legal expert, but fortunately, we do have a couple with us today. So I think my computer's doing something weird. So David and Martha, why don't you tell us a little bit about your backgrounds just to kind of set the stage? So Martha, why don't we start with you?
Okay, thank you, Blair. Thanks for bringing this topic to the fore. I was a network engineer before I was a lawyer, so I come to this space from the corporate consumer side, which has been very interesting. And in the last couple of years, I've been teaching a graduate level class in ethics and IT, and certainly the ethics of AI has come up in a great number of contexts, and I've gotten very interested in the topic, and I've written about it a lot and spoken about it often to a very diverse group of audience members.
Great. And David?
I flipped in the other direction. I'm currently an analyst covering business communications and a content creator at Let's Do Video. But previously, I was an attorney. I practiced for 10 years in Louisiana, passed the bar in Louisiana, New York, and Florida, but I'm not currently practicing.
Okay. So let's talk about some of the lawsuits that are taking place and what they're all about. And, again, talk about user consent and what do the vendors and enterprise customers need to be thinking about, when it comes to consent and how the data is being used. Martha, do you want to start?
Sure. And I guess I'd like to use the Legal Shield case just as a brief example. What is alleged, and the key word there is alleged, is that TalkDesk, while providing the contact center service, was collecting, retaining, and then using the conversations between Legal Shield and its customers. This is fraught with problems, but one of the most important ones that hit me right away was it's technically a violation of attorney-client privilege right off the bat. I don't know how Legal Shield gets around that, but the fact is customer data, which was very personal and potentially very private, was being shared by a third party, which very simply creates a huge risk for anyone who's using a service like that. The other issue that I wanted to raise about this is that there is a class action bar that is very hungry to go after any violations that it perceives of consent violations, and this is kind of a no-brainer. I have read the case filing. It's nowhere near a decision. I've just read the pleadings, and some of the arguments that are made are valid and others are not. But the fact that TalkDesk is alleged, and again I use the word alleged, to have taken data that did not belong to it from party one who was dealing with party two, where TalkDesk was merely the intermediary, creates a huge problem. And then the fact that the customers weren't aware, the people who are calling Legal Shield were unaware that their information was being violated in this way is to me a significant issue.
And again, in this case, it's TalkDesk, but it could be any of the CCaaS vendors because most of them
Absolutely.
do things, the same way. David, do you want to talk about any of these cases or why this is also
Sure.
complicated?
Yeah. I think I can explain why it's so complicated. But a quick thought on the class action thing. The reason everyone's so hungry for it is if you're an attorney that has you get those things in the mail. You got $2 in a class action lawsuit. If you have 100,000 or 100 million clients, the attorney gets $200 million. Everyone individually gets $1, but the attorney makes a lot. But the reason this is so complicated is because we don't have a lot of legislation on it. Ideally, there would be laws, and I think there's one in Europe that's about to happen. But there'd be laws. It's going to be California first, probably, that says, okay, this is how you could handle AI. This is what you could do with the data. This is how you can access things. And then if there's a lawsuit, it's easy. The plaintiff says, here's the proof that they didn't follow the law, and Zoom or TalkDesk or whoever says, here's the proof that we did follow the law, and the judge says, I'm looking at the facts. Here's my conclusion. But we don't have those laws, so we're using other laws, and they apply. But when they were written, the legislators didn't say, let's make it clear in this law how it applies to AI, because they didn't know about AI. So that they're coming from left angles and right angles. And I'm not going to give a whole thing, but there's two legal theories that are being used. And you're going to see they're not really AI laws, but they apply. And they're privacy laws. And we do California because California is the most strict. If you want to make sure you're legal, follow California laws, you're probably good everywhere else, especially with this privacy stuff. And I'm not going to make this too long, but there's two things I want to get to. So the first legal theory is what I call the recording wiretapping stuff. And the second legal theory is the using the data stuff. And the recording wiretapping stuff, if this AI is summarizing my meeting, is it making a recording of it somewhere? Did I give it permission to do that technically as it's required to under the law? Or wiretapping. Obviously, I can't hack your computer and listen to your Zoom meetings. But if Zoom AI is somehow listening to my Zoom meetings and I didn't give it permission to listen, isn't that wiretapping-ish? It might seem like a stretch, but it's enough to go to court. So I think those are what's going to happen. We don't know because it hasn't happened yet. Is that a good legal argument? We don't know. They're making it. Lawyers better than me are making it now. That's why it's so exciting. But I think the stronger legal argument is the using the data legal argument, because those laws are harsh. I have a website. If you put your email on my website to get my newsletter, I can only use your email to give you that newsletter. I can't do anything. I can't share it with anyone. I can't use it to send you something else. If I get your address to send you a t-shirt, I send you a t-shirt and I can't do anything else with that address unless I say, I'm also going to use your address for this. Do you agree to that? Those laws are harsh and they're new and they're good. And so if I'm using your data to train my AI and I didn't get your permission, technically that law seems to apply. Now, when they wrote that law, they weren't saying this is for AI training as well. They didn't know, but gosh darn it, you read the law, it seems to apply. So what's going to happen? We don't know. It seems like it's, the right way is legislature, get up your butts and write some laws so we know what to do.
So
I have a question about.
Let me just follow up on that for a second.
Yep.
And that is, David's right. The California law is the most strict, but the fact is, as each state, and there is no federal privacy law that's not specific to an industry, unlike HIPAA or fair credit reporting, but each state's privacy laws are going to be just a little bit different. And being compliant with them for the provider, for the CCaaS and UCaaS provider, is going to be, some might call it a huge challenge. Others might call it a nightmare. They're not going to be the same. And the other issue is the EU made a concerted effort to be the leader in AI regulation, and some of its policies are already in play. Others become effective throughout this coming year and the next 18 months. So not only do you have some states that have requirements, some states have none, but you've got to be compliant for citizens of the EU with the EU rules, and those are much more stringent and much more specific than GDPR, which also affects entities who are processing or receiving data that belongs to citizens of the EU.
So I've got a question about the recording that you mentioned, David. So like if I'm in, let's say, a Zoom meeting, it'll usually come up, this meeting is being recorded, and then I have to click got it. Is that giving implicit consent when I click got it?
It depends.
Consent for all uses. I would argue I'm consenting because I thought you were recording it so that you could watch it later. I didn't consent to you to use it for AI. There's consent and there's consent, and of course, if I'm on the other side, I would say, of course it means. If I was the lawyer from the other side, I'm being paid to represent. I'd say, of course duh. Did you click consent? Yeah, Your Honor, they click consent. They click consent. We're done. Case dismissed. But if I was on the other side, I'd say, Your Honor, consent to what? And what is the answer, Martha? What's the answer? We don't know.
So the answer is, interestingly, within the past week, and I am not making this up, the FCC has opened a proceeding to examine customer service issues within the communications industry that are specifically geared towards contact centers. And the comment period is open through November 22nd. But they're very concerned about this very issue. I mean, what is consent? And is it easy to revoke consent? Is it as easy to revoke consent as it is to grant it? These are really important issues. And certainly if the FCC is talking about doing a rulemaking, this is getting some pretty serious attention.
And Blair, if I could just jump in from the IT pro perspective, the platform. So if I talk about Zoom specifically, like if you're an IT pro, you can actually go in there and that warning, or the either audible or visual warning when you record a Zoom call, you can turn that off. Don't do that as an IT pro until the legal thing. But you have that option, and you see the vendors because they're not sure. Just as David and Martha have said, for example, on with Copilot in Teams, you can actually make it so that if somebody starts a Copilot either recording or transcript, all the people are immediately muted and their video is turned off until they agree that they are okay with you being recorded, both from an audio and visual perspective. So the vendors, because they're not clear on how the legal kind of cases are going to get sorted out, are starting to add a whole bunch of options to their platforms. But as an IT pro, please don't go and disable any of those without talking to your own legal counsel.
So Kevin, we'll call that a BCStrategies tip, right?
Or there you go, Steve.
Okay.
BCStrategies tip.
Okay, so who wants to ask the first question? Melissa, do you want to go?
I should probably unmute before I try to ask. So one of the things that I've seen a lot of discussion about is copyright and intellectual property, like who owns it, and if something's created by AI, or maybe from a foundation of other stuff, like what can be copyrighted, who owns that intellectual property. So what do y'all think about that, and how does that apply to, for example, I don't know, a contact center that has recordings of their customer information? Are there any copyright issues there?
I'm not sure that copyright applies there. What I will say about copyright is that there are a number of lawsuits that are pending that involve the use of copyrighted information to generate large quantities of data that can be used and analyzed for other purposes. And entities like Reddit and the New York Times and the Washington Post are those who are very concerned that their information is being harvested and then reused to to help train third parties' AI. The only court case that I'm aware of that has been resolved is not about this issue specifically, but what it specifically addresses is whether a piece of art that was created strictly by AI is copyrightable. And in the U.S. courts, the answer is no. But the plaintiff the person who brought that case, not the plaintiff, person who brought that case has also brought it in Saudi Arabia and the UK, trying to get a different answer.
I would like to add a question to that question, because this is so new and so different. I've been using Copilot to generate graphics for me. And some of the graphics that it's generating are copyright questionable. By the way, it won't draw people. It won't even draw me. If I give it a picture of me, it's so afraid of getting sued about drawing a person badly. It will not draw a real person, but it'll draw cartoons. Some it will draw, some it won't draw. I don't know if it's about copyright or whatever, but I said, draw me a Flintstones background. Obviously, I like having my fake backgrounds. And it was a recognizable that kind of looked like Fred. It kind of looked like Wilma. If I put that up behind me now and I do a live stream on YouTube with the Flintstones background owned by Warner Brothers or whoever owns it, who gets sued? Does YouTube get sued because it's their platform? Do I get sued because I'm the one doing all of it? Does Copilot get sued because Copilot drew it? It was Copilot's little magic hand that drew it. Does Microsoft? Microsoft does Copilot. So I think at the end of the day, I get sued. That's not my lawyer feeling. That's my gut feeling. That's my what seems fair feeling. But if you ask me to put on my lawyer hat and say who gets sued, I would say everybody. Martha, you with me? Everybody gets sued. So I've been doing it.
You throw spaghetti against the wall and see what sticks. And the problem with that is all of the different entities that get sued incur legal fees to fight their battles, whether the case is really valid or not.
Now, what happens, Martha and David? I'm going to jump in here because the Microsoft example, like Microsoft has come out and said that they will indemnify, a very legalistic word. They will indemnify any kind of corporate licenses. So if you have a paid license for Copilot and you use the Copilot services, Microsoft indemnifies you if you get sued, right? So does that mean that they step in and kind of, cover my court costs? Or David, in the case where you use Copilot to generate this, would that be what the indemnification? I'm sure that there's a whole legal agreement behind that, but in general, is that what that means?
Do you mean, does it protect you?
Yeah, I guess. Does Microsoft come to David's defense because he used Copilot to create something that looked like the Flintstones?
Well, there are two issues with that. With most indemnity provisions, the first is it probably doesn't protect you. But the second issue, even if you were to invoke it, often what is required is that if you kick in the indemnification provision, then the person who has indemnified you controls the legal defense. So you may be sued, but somebody else is running the defense, and it may not be in your best interest. It may be in their best interest. So that's all. Reading indemnity provisions is pretty dull. I think, David, you would agree with me on that. But the fact is, one of the components that's usually there is who's responsible for the defense, and it's often not the person who's been sued, and that's an issue.
Okay. Right. Well, to take it a step further. To take it a step further, what if, and this is classic, right, for any vendor, Microsoft indemnifying themselves, as part of this whole thing?
I'm not sure you could do that because you have to be. Indemnity is when you step in and protect someone else.
Yeah, I don't think you can indemnify yourself.
Oh, okay.
Nicholas, did you want to ask something about governance?
Yeah. So I know it's not strictly legal, but it is so important for many of the businesses I talk to. Is what are the best practices to establish the governance at the company level that can be the kind of the guardrail for all your AI initiatives and projects? Maybe you can share your experience and what you think should be top of mind.
So let me start, and then David, jump in. So I'm looking at a slide that I gave in a presentation a couple of weeks ago. I think there are eight elements of law that need to be considered for exactly this reason, or these reasons, and they're contract, allocation of risk and negligence, privacy issues, products liability. Products liability is a big one because those are often big settlements. Antitrust issues, international, intellectual property, and then communications technology. So there are 8 different segments of law that need to be considered in terms, and 8 different people who need to be sitting at the table making these decisions, because that's it. Any one of those areas could be the one.
Yeah, and what I'd like to say is, the responsibility is really on the vendors to make sure that these tools are all safe to use. It shouldn't we shouldn't have to give too much advice to the companies that are using them, because they should be safe. But as we're seeing, if you're a company that works with legal customers and you're using this AI with their attorney-client privilege materials, you're going to get sued too. So unfortunately, yeah, the companies do have to worry about governance. I wish it wasn't that way. It should just be the vendors. You make this tool, make sure the tool's safe to use. But in general, it is a problem that all the states are different. It can't just say follow this. But if you're trying to do a quick and dirty job, generally, if you're okay with California, you should be pretty okay. That's not like legal. David said we'd be okay, and we got sued in Maryland. You never know. Each state is different, but usually California is the most strict. It sets the highest bar for these kind of things. So if you meet that bar, that's a good. Your policies should be okay. Or it's a good place to start. Is a better way to put it.
Thanks. Over to you, Blair.
Well, I've got lots more questions. Steve or Melissa, do you have anything you want to ask before I get into mine?
Yeah, Blair, please. Yes, thanks. So actually, when I said indemnity, I was thinking more about hold harmless, right? So how can Microsoft, as an example, hold themselves harmless, for any lawsuits pending based upon AI, production, if you will?
They probably already have.
I would say nice try.
Yeah. Okay. No, I was thinking more along those lines when I shared that. Okay.
I'm thinking they already have. I'm thinking at some point I signed something with Microsoft that says if I use their AI to do the Flintstones, and it probably even has Flintstones in there, that they won't get in trouble and I will. Who you heard that thing about someone who signed up for Disney Plus to watch the Disney on TV. Somewhere in the Disney Plus agreement, it said if you happen to go to our resort and have a food allergy and die, we're hold harmless. And it was technically legal, but they got in so much trouble. They said, okay, we're not going to enforce that. But can Microsoft hold me harmless? I mean, we could always fight it in court, but I wouldn't be surprised if I already signed something, already clicked something.
Sure.
I already clicked something.
But you also can't sign away your rights. I mean, you can sign it. It can be used in court to make you look bad, but it's like signing a permission slip for school. Yes, you gave permission. Yes, you said it was okay, but that doesn't mean that you can't sue if things go wrong.
Yeah. So let me ask you about transcriptions and call recording, which we were alluding to a little bit earlier. But let's think of it in terms of how obviously these recordings that are being done systematically, right, in just about any contact center these days, that it goes into a database which is transacted or actually transformed from speech and text analytics, right? So therefore, that becomes part of the knowledge management, for further information. So that goes back into AI agent assist and other kinds of tools. Or even just the transcription or summary itself that could become, potentially discoverable. So, David and Martha, what are your thoughts about, those two areas?
Well, just a quick story to show how hotly this is going to be contested. The using legal stuff for anything. It's like lawyers we're going to have to talk about this first. Well, back in the mid 90s. My boss, who was he did a great deposition. He would get people yelling and screaming, and he decided he was going to bring in a little video camera, which no one was doing at all at the time. And he said, the law says I can record. But when they wrote that, there was no such thing as video. It obviously meant audio recordings we had a paid, what are they called? Martha, help me. I'm blanking on the
Like a dictaphone or
yeah, dictaphone person, stenographer. We had
yes.
Okay. We're allowed to record. Doesn't say you're allowed to do video. They got into almost a fist fight, and what happened at the end was the other attorney was holding up a book in front of the camera, so you just see a book in front of or it was his hand for the entire deposition, and then they fought it out in court because just the idea of turning on a camera in a deposition it's new. We're arguing about it, and within months there was legislation in Louisiana where nothing happens fast, limiting. You can't have a camera unless the judge says it's okay. Just saying exactly how to do it. So as far as what are the rules about using legal transcriptions in AI, it's like, whoo, that's not going to be an easy answer.
Right. Martha, any thoughts on that? Because I have just one more question.
No, I'm comfortable with the way David answered it.
Okay. So then now, with AI, obviously not just Copilot, but, ChatGPT and other types of, AI, technologies, platforms, if you will, have been noted for developing or cautions, if you will, with customers around the term hallucinations. Okay. Where the platform is actually providing incorrect answers, right? So there was a classic example of Air Canada that, gave a refund to one of their obviously customers, and then they denied the refund later on, and the lawsuit itself didn't compensate the individual. What was it, under $1,000, Kevin, if I remember? But at the same time, it legally didn't uphold in court, where effectively Air Canada was saying that they were not liable, even though the AI bot said they were going to give them the refund. So that got denied in court, and therefore, that's an interesting piece. So what about the rest of these kinds of hallucinations where they're providing inaccurate information, or how do we even control the level of accuracy around, this knowledge management, so to speak?
So I would say that it's a complex issue for sure, and it is important to remember, top of mind always, that humans make mistakes too. So I would say while there are legal consequences, I think the business consequences may be even steeper. I think once Air Canada sent out the note that said you're eligible for a refund and then decided not to do it, regardless of whose fault it was, it looks bad. So I'm not sure if that's a direct answer to your question or not, but AI makes plenty of mistakes, but so do humans. And it's a question of how you deal with them.
Mm-hmm.
And Kevin, I think that goes into something you wanted to bring up.
Yeah, no, and I think, Martha, exactly what you said. I think too often people are focusing like this Air Canada. I mean, it could have just also been a human agent that, of course you train your agents and they may, maybe as an organization, I provided inadequate training or maybe things changed and I didn't update the training. And so human agents can provide misinformation. From a legal perspective, I mean, is there a difference between a human agent providing misinformation or an AI chatbot providing misinformation? Or is it just I'm worried about the AI piece because it's new? Or is it, I guess from a legal perspective, does it make a difference who's giving my customers incorrect information?
I actually got a real answer to this one. It depends. It depends.
Oh,
Great.
I'm sorry.
What does it depend? What does it depend on?
So, but let me give you, and I lean towards blaming the user and not the tool. Let me give you an example of why. I'm trying to make an analogy because I love, Kevin, by the way, that you make an analogy between it being a person. By the way, people should watch. Kevin and I have a show, The AI Chefs. We give tips on how to use AI and we talk about using it as a person. But let's say I'm back to my attorney days and I'm busy. I call up a temp agency. I need a paralegal to help me with a big case. They send over a young kid. She seems awesome. I ask her to write a brief for me. I don't check it thoroughly. I go into court. There's stuff in it that is not right. And we lose and I get in trouble. Can I sue the temp agency? Hey, good luck. I don't think a judge is going to love it. I mean, yeah, you sue whoever you want, but it's, waste your money. Do I sue the kid? Yeah, great. Good luck. A judge is going to, poor kid. The judge is going to love the kid. It's my fault. I'm the lawyer. So same thing. Let's say instead of hiring an agency, you're all nodding your head. See where I'm going? I have ChatGPT on my right screen. Write this brief for me. I go into court. Stuff's not right. I get embarrassed. Do I sue ChatGPT? Do I sue OpenAI? Well, of course I do. Is it going to work? Probably not. I mean, even without the disclaimers the multiple disclaimers that they have, I'm the lawyer. But that is such a very specific hypothetical. Let's come up with 100 million hypotheticals in different scenarios. And I think some of them we might say, well, in that case, maybe they could sue. I'm not thinking it at the top of my head, but I really think it's an it depends.
Okay, no, that's good. And I like the example that you provided. Thank you, David.
So I know we're running low on time, but I wanted to bring up one other thing. Martha, I know you have some thoughts about AI and sentiment and emotion. Can you talk about that a little bit?
Sure. I think that is venturing into a big black hole that is deep and potentially bottomless. Because one of my big issues with AI deployment generally is that there are biases that are built into it, that it's just a function of what it is. And who decides what an emotion is, or who's being emotional, who's angry, who's making those decisions, I think is very complicated and not necessarily very often wrong. As I said before we started recording, many years ago, I worked on a contact center. And one of my takeaways that has served me well since then is that if I'm angry and I reach a contact center, I am going to be as nice as I can because nice plays better. And I'm not sure that I want anyone else measuring my or qualifying or quantifying my behavior based on someone else's analytics. I just think that's fraught with danger.
Mm-hmm. Everything you said makes sense. But then when I see the demos that I saw recently at Zoomtopia and WebEx1 of what they're doing with AI in the contact center, it seems maybe just those particular implementations seem more harmless to me, because it was someone's at the contact center and the person who called in said, hey, the tickets I thought I had, it said they're sold out, but they weren't supposed to be sold out. What's going on? Say, oh yeah, I'm able to get you 2 other tickets in a different part of the theater. And then the sentiment thing said, they're still unhappy, give them a free t-shirt. And the agent said, hey, we really appreciate you taking the new seats. Can we give you a free t-shirt? And then the people are like, oh, you guys are awesome. I love you. And the sentiment analysis thing was like, yeah, they're happy for reals now. That seems kind of, maybe it's just that particular invitation. It seems kind of harmless. Like, what could go wrong? The worst case scenario, you gave them a free t-shirt that they didn't need because they were already happy. And I think the question isn't, the question is, how good is it going to be? Is it going to be not as good as a human, which is already struggling with this? Like you said, that's hard to do. Or is it going to be better? Maybe the sentiment analysis say, hey, she's acting nice because she's smart and she wants to get better service, and she's acting happy. She's really not happy. This is not a happy customer. She's not going to come back to us. Give her free stuff. Give her 3 free months of service, even though she's acting happy. Maybe the AI is that good. I don't know. Or maybe it will be that good. So I don't know.
Okay, well, there are so many issues that we can keep talking about, transparency and social media, and there's just so much involved. So I think we're going to have to do this again, and hopefully there will be more rules and regulations, and things will be a little more clear cut in the future. But for now, it's going to be interesting days for a while. Mm-hmm. So thank you to my BCStrategies team, and especially Martha and David for your legal expertise. Really appreciate it. And, it's always great to have you guys to turn to whenever we do have a legal issue come up. So that's what I love about our BCStrategies group. We've got lots of different expertise. So thank you all for joining us. Thank you out there for listening and participating, and tune in next time. And thanks a lot.
Thanks.
Thank you.